Let's start. So let's have section 17. You'll remember that when we discussed section 12, we already stated under section 12, paragraph 3, that violation of section 12 or section 17 results in the inadmissibility of any confession or admission. Now, take note of that section 17 deals only with 11 words. No person shall be compelled to be a witness against himself. Now, violation of that right means inadmissibility of any evidence obtained. Now, let's go to the very interesting cases involving this one. First is your Social Justice Society versus PIDEA. So, your Dangerous Drugs Act, Republic Act 9165 provides that PIDEA is authorized to enter into high school or colleges and conduct random drug testing to college and high school students. Now, are students at the College of Law covered by that? Yes, because you are only enrolled in a bachelor's degree. So, they can. Now, what happens if the PDEA will enter your room at UC Law, get a sample of your urine, and it turns out that you are positive of prohibited drug? Now, does that violate your right against self-incrimination? The Supreme Court in the case of Social Justice Society, no. Why? Because even if ARA will be found positive of shabu, she will not be charged criminally, but that finding that she is positive of prohibited drugs will be used by the government for her to be treated in a government rehabilitation center, meaning the government will protect the youth. So instead of imprisoning you, you will be treated by the government in any rehabilitation center for free. And therefore, there is no violation of your right against self-incrimination if you are forced to give a sample of your urine in connection with Republic Act 9165. Take note, it applies only to high school and college students. But note of the case of Attorney Manuel Lacerna versus Dangerous Drugs Board. This one now is different. Ara, for example, was arrested for a crime of staffa. Staffa. Now, after being arrested, under your 9165, a person arrested for commission of other crimes, she will be brought to the NBI testing laboratory or PNP crime laboratory to determine if he or she is positive of prohibited drug, and thereafter he will be charged or she will be charged for violating Section 15 of Republic Act 9165. Now, is that violative your right against self-incrimination? The Supreme Court said yes. Why? You were arrested for a minor crime, for example, and then they will make you give a sample of your urine, and if you are found positive of prohibited drugs, instead of facing only a simple case of theft, you also have a second criminal case, which is violation of Section 15 of 9165 that violates your right against self-incrimination. Now, let's go to the most controversial case on right against self-incrimination. That is the case of Chavez versus Court of Appeals. So, this case is very simple. For example, Albert was arrested for kidnapping in serious illegal detention. Now, he was arraigned. he entered a plea of not guilty. What was the crime he was charged of? Kidnapping and serious illegal detention. So after arraignment, the judge said, Judge, that a prosecutor, present your evidence now. So the prosecutor will now present his evidence. And what did the fiscal said? Your Honor, yes, I am now presenting my first witness. My first witness is the accused himself. Take note, my first witness is the accused himself, Cesar Chavez. Naturally, the lawyer of the accused said, Your Honor, we object. And the judge said, what is your basis for objecting? He was not able to say, Your Honor, that will violate my right to the client involving Section 17. And the judge said, okay, fiscal, you can present the accused. Nakita nyo, the judge, the fiscal, and the lawyer of the accused are all graduates of Lausium University. You can just imagine, the fiscal will present the accused as his witness against the accused. And the lawyer of the accused could not or do not know what law or constitutional provision to justify his opposition. So here, Chavez took the witness stand, the fiscal questioned him, and then after his testimony, the fiscal asked, he is now ready for cross-examination. Now, will the lawyer of Chavez cross-examine his own client? No, he will be stupid, correct? And then the judge said, fiscal, who is your next witness? Your Honor, I have no other witness. I have already proven the guilt of the accused. I am now resting my case. So the case was decided. Chavez was convicted. Life imprisonment based on his own testimony. So, on automatic appeal, the Supreme Court said, this is the story of three lawyers who were classmates at the Lausium University. All of them, the fiscal, the judge, the lawyer of the accused, do not know the right against self-incrimination provision of the Constitution. The Supreme Court said the entire proceeding is hereby declared null and void, and therefore you have to retry Chavez all over again. He present evidence to prove his guilt using other witnesses, not he himself testifying against himself. Very clear. Now, the next question is there a way where an accused himself can be presented as a witness by the prosecution? The answer is yes. You have the case of Galman versus Justice Pamaran of Sandigan Bayan. And what is that? When can you be allowed or when can you testify? Even though you are the accused, you will be a witness for the prosecution. The answer is if the prosecution will grant you immunity. What do you mean immunity? You will not be sentenced to any imprisonment. So, you, unfortunately, you are not yet born when Joseph Estrada was tried in the Sandigan Bayan. He was charged together with Chavit Singson of plunder and graft in corruption. Why? Chavit Singson was the one collecting, creating money for illegal gambling from Lawag or Ilocos Norte up to Bicol, and at the end of the month, he is remitting his collections to Estrada. Second, plunder. Estrada and And Chavit Singson divided the 200 million tobacco fund for Ilocosur, 130 million for Joseph Strada, 70 million for Chavit Singson. Now, both of them are facing graft in corruption and plunder. The government at the time wants to convict Strada, and in order to have a very strong evidence against him, they extended immunity to Chavit Singson. So Chavit Singson now testified. He said, yes, I collected Hueting money. I remitted it to President Strada. I left a portion of that for my commission. Also, we divided the 200 million tobacco fund, 130 million for him, 70 million for me. Question, can the court convict Chavit Singson? No, because he was given immunity from prosecution. Now, how about if the question will be asked of him? Aside from this kalokohan na ginawa nyo ni President Strada, do you remember if you committed other crimes aside from plunder and graft in corruption? How about if Chavit will say, yes, kami pa ang pumatay kay Corbito and Dacer? No, maybe you have not heard of the Corbito Dacer murder. These are the two men killed also allegedly upon orders of Joseph Strada, and their body were dumped in Cavite City. Question, can you now prosecute Chavit Singson in that double murder case? The answer is, it depends on the kind of immunity extended to Chavit Singson. So, take note now of your question number 20. What are the two kinds of immunity and distinguish them? One is transactional immunity and the second one is use immunity. Now, what is transactional immunity and what is use immunity? Now, from the word use and transactional, when you talk of transactional immunity, you are immune only of the transaction that you were given immunity. So, if Chavit Singson was given transactional immunity, he is immune only from prosecution in the graft in corruption and plunder case. That is the only transaction that he was given immunity, kung transactional immunity. So, how about the crime that he mentioned, murder, that is not covered by the transactional immunity, then he can be prosecuted for murder. But if he was extended use immunity, so use immunity meaning absolute immunity. How about transactional immunity? Limited immunity, meaning only the transaction that you are given immunity that you cannot be prosecuted. So, if he was given use immunity, he testified in the plunder and graft in corruption case. He mentioned about murder that he committed with Joseph Strada. Can he be prosecuted there? No, if he was extended use immunity. Kahit nga sabihin niya, in fact, kami pa ni Joseph Strada ang pumatay kay Rizal, still, he is immune. Why? Because he was extended use immunity. So, you know now the difference between transactional immunity and use immunity. Transactional, limited, only that transaction that you are given immunity that you cannot be prosecuted or tried and convicted. But use immunity. All other crimes that you might have committed, you cannot be prosecuted anymore. That is use immunity. Now, let's go to specific cases on the application of your section 17. You have the case of Villaflor versus Summers. So, it was as many times in the bar exams. Very simple. It's like my neighbor. He worked in Dubai for the last 2 years. Last 2 years. He arrived last month. He found out that his wife is already 8 months pregnant. 8 months pregnant. So, was he the one who caused the pregnancy of his wife? Or the wife committed adultery? Very obvious. Since he was there in Dubai for 2 years, the wife committed adultery and therefore he filed a case for adultery. Now, during the trial, the prosecutor requested the judge, Your Honor, may we pray for an order requiring the accused, the woman, to give a sample of her urine to determine whether she is pregnant or not. So, if it will turn out that she is pregnant, that means that she committed adultery. Question, if she will be forced to give a sample of her urine, will that violate her right against self-incrimination because she is providing evidence against herself? The Supreme Court at the time said, there is no violation against the right to self-incrimination. Why? Because Section 17 applies only to testimonial compulsion. Meaning, if you are forced to talk, that is where Section 17 applies. So very clear. If you are not forced to talk, you are required to provide evidence without talking. The right against self-incrimination does not apply. You look again at the third paragraph of Section 12. What does it provide again? Any admission or confession obtained in violation of this and Section 17 shall be inadmissible in evidence. So, what do you understand, Ara, of the word any confession or admission? Meaning, it involves only testimonial compulsion, meaning you are talking, correct? So, if they will get evidence from you without talking, then you cannot invoke the right against self-incrimination. So, here, the pregnant woman is being required to give a sample of her urine. Is she required to talk? No. She only urinates and that is all. Unfortunately, the result of the examination of her urine might be the reason for her conviction. Now, take note that the Supreme Court changed that testimonial compulsion requirement in the case of Beltran versus Samson. So you have here comes a man charged of falsification and also took the salaries of several co-employees. So there was a payroll. He went to the cashier and then falsified the signature of his other co-employees and received their salaries. So, he is now facing a case for falsification and then, of course, malversation of the salaries of his co-employees. Now, during trial, he was asked, is it not a fact, Mr. Madero, that this is your signature opposite the name of your co-employees? And then he said, No, that's not my signature. Ang pangit naman yung signatures nila. That is not my signature. So, because he denied the signature, what was the next question of the fiscal? If you say that those are not your signature, I am giving you here a coupon bond. Please take down the following so that I can compare whether or not that is not your signature or that is your signature. So, of course, Joshua said, no, you are now requiring me to give evidence against myself. But the judge said, no, there is no violation of your right against self-incrimination. Why? Because you are not required to talk. You are only required to write. So, insofar as Villaflor versus Summers, it applies only to testimonial compulsion. But the Supreme Court in the case of Beltran said that applies. The right against self-incrimination applies if a person is required to perform something with the use of his intelligence. So take note of that. So even though you are not made to talk, but you are made to perform something which requires the use of your intelligence, like writing. The Supreme Court said, writing is not a mechanical act, it is an act which requires the use of a person's intelligence, and therefore the right against self-incrimination applies. So very clear. Even writing is covered by the right against self-incrimination. Now, you also have the case there of U.S. versus Tang Teng. He allegedly raped Miss X. And Miss X said, after he raped me, I suffered. I found out that I was suffering from gonorrhea. Now, can they force the accused to give a sample of his urine to determine whether or not he is really afflicted with gonorrhea? And if it turns out to be true, that will increase or improve the evidence of the prosecution, and he will be convicted. But again, the Supreme Court said giving a sample of your urine is not something that involves testimonial compulsion, or second, there is no need for the use of your intellect. Maybe you will question that. Can you be forced when you will have a urine? Hindi ba? It is controlled by your brain. Maybe even though kahit nakaihi ka, but your brain tries to control you, you can control, correct? Walang lalabas na urine. But the Supreme Court said, giving a sample of your urine does not involve your intelligence. Or the other cases like Otadora, Olvis, and so on. So let's have this example. One night, May Francis was awakened. Why? She felt that there's a man on top of her trying to remove her clothing. She shouted. And then her parents were already knocking at her door. But she was able to glance at the man. The man is already completely in the nude. But because of the fact that the parents of May were already knocking at her door, the man jumped out of the window. Leaving his shoes, pants, and shirt inside the room of May Francis. May Francis was able to have a glance at him because of the street light. And she said it was It was Albert. So Albert was charged of what crime is that? Is there such thing as attempted rape? Is there such thing as frustrated rape? None. Maybe the case is acts of lasciviousness. Now, during the trial, the fiscal is in possession of the Adidas shoes of Albert, the Wrangler pants of Albert. Now, can he be required to try the pants? During questioning, Mr. Witness, is it not a fact that this is your pants, Wrangler pants? He will say, no, that's not my pants. I do not use Wrangler. I use only Levi's. So, can you now force him to try that Wrangler pants? And if it fits, then he will be convicted. Correct? Or the shoes. Is it not a fact that this Adidas is your shoes? He will say, no, that's not my shoes. I only use Nike. Can he be forced? Again, yes. Why? Because there is no testimonial compulsion. There is no need to use his intelligence in trying to fit the shoes or the pants. Now, take note that definitely, absolute, in criminal cases, the prosecution cannot present the accused as its witness. Now, how about administrative or civil cases? Can you present your opponent, the respondent, or the defendant as your witness? Very clear under your law on evidence, you could present the adverse party as your witness. He cannot refuse to take the witness stand. But take note, he can refuse to answer questions that calls for incriminatory answer. Example, we have here Giselle constructed a house without building permit. Now, the city mayor ordered the demolition of her house. She filed a case for injunction before the RTC Baguio to stop the demolition. Correct? Now, if you are the city legal officer, the lawyer of Baguio City, can you present Giselle as your witness? The answer is yes, because it is a civil case. Can she refuse to take the witness stand? No. But as I said, she can refuse to answer question if the answer would incriminate her. So, I am the city legal officer. I will call Giselle to the witness stand. My question was, Madam Witness, is that house subject of this case your residential house? Yes, sir. How much did you spend for the construction of that house? I spent 5 million. My next question is, Madam Witness, do you have building permit for your house? Now, can I force her to answer? Of course, she does not have a building permit. If she will answer yes, that will incriminate him. She will be found guilty of violating Presidential Decree 1096 or building without permit. So, if my question is, do you have building permit? She could say, I refuse to answer on the ground that it will incriminate me. So, civil case, administrative case, the other party cannot refuse to take the witness stand but can refuse to answer specific questions that tend to incriminate him or her. Now, let's go to your right to involuntary servitude. Very simple provision. You cannot force a person to perform something against his will. You remember Kaungka versus Salazar? This is the housemaid. She wants to transfer to the other house because she is given a higher salary. Can you force her to work for you up to December? Because her mother already received her salary from you? The answer is no. Because you are now forcing herself to do something against herself without valid reason. So, in the case of Aclaracion versus Gatmaitan, you have here stenographer in court. So, Pauline is the stenographer in court. She took the stenographic notes of testimony of witnesses who testified today, May 19. May 31, she resigned from the judiciary. Why? Because Globe Telecom gave her a higher salary. Now, when the judge checked the record trying to decide the case, there is no transcript of the testimonies of the witnesses who testified today. Now, can the judge force Pauline to transcribe the testimonies of the witnesses today? In this case, Pauline said, no, I'm no longer connected with the judiciary. You are now forcing me to do something against my will. Can the judge force Pauline, or else she will be cited for contempt? She could be. She cannot invoke the right against involuntary servitude. Why? She took down the notes today, May 19. She was paid her salary up to May 31 when she resigned. Therefore, she was already paid her salary today, and therefore, she has to transcribe her notes today. Very clear. That is not forcing herself to perform something against her will. Otherwise, she will be delaying the administration of justice. Now, let's go to another very, very controversial provision of your Constitution, Section 19. It provides that excessive fines shall not be imposed, nor cruel, inhuman, or degrading punishment be inflicted. Neither death penalty shall be imposed except for heinous crimes as may be described by law. Any death penalty imposed upon the ratification of this Constitution shall be reduced automatically to reclusion perpetua. So the first question is the death penalty abolished by the Constitution? The Supreme Court, in the case of Gabara, Masangkay, Atencio, Intino, wrongly held that the death penalty was already abolished. You can just imagine the Supreme Court making that mistake. A simple reading of Section 19 shows that death penalty was not abolished nor prohibited by the Constitution. In fact, Section 19 says you can have death penalty if Congress enacts a law on death penalty for heinous crimes as may be defined by law. So, heinous crimes, death penalty, if Congress will enact a law like that, can be. In fact, they enacted one in 1998. That's why Leo Echegaray was the subject of lethal injection. Now, is death through lethal injection cruel and unusual? The Supreme Court said no. Why? Lethal injection is the most humane way to implement the death penalty. Why? Because there is no pain. They will just inject you with something, and in less than 5 minutes, you will slowly go to sleep, not to wake up again. No pain. No pain. So, lethal injection is the most humane way of implementing the death penalty. So, Geraldine, if you do not believe that, you can go to Mercury Drug and then bili ka. And then you inject yourself, no pain. You will slowly be going to sleep, not to wake up again. So, if you want to commit suicide, yan na lang. Kaya, stupido nga yung mga nag-suicide, like jumping from the 18th floor of a condominium unit. Like the wife of Rodi Pariñas, the congressman of Ilocos Norte, the actress, correct? She jumped from the 19th floor. You can just imagine that. Or others, umiinom ng Polidol. Yung pinag-i-spray, ang pangit ng lasa nun, correct? Dapat na lang, bili ka na lang sa Mercury Drug yung sinasabi na to. Correct? So, very, very humane. You will not feel anything. Now, so, cruel and unusual punishment. Now, that is 20B, the question in your finals. When is a penalty cruel and unusual? The answer is People versus Stuesta. A penalty is cruel and unusual if it is shocking to the conscience of the community and disproportionate to the crime committed. So very clear. When the penalty imposed is disproportionate to the crime committed and it is shocking to the conscience of the community, then the penalty is cruel and unusual. Now, is firing squad as a way of implementing the death penalty cruel and unusual? The Supreme Court said yes. Before, they were using the electric chair. Again, if you read Ichigarai, it's better for lethal injection. Why? Because if you will be penalized death through electric chair, you will be connected to a 25,000 volts electricity. What is the voltage in your residence? 220. Makuryente ka lang dyan, ang sakit na eh. You remember 25,000 volts? The switch on, you will be trembling for several minutes even though you are very, very fair like Ara. Ang puti-puti mo, after 5 minutes, you will be looking like Obama already. Why? Because you will burn with the 25,000 volts. Now, in the Philippines, there are punishments not allowed here but allowed in other countries. Were you able to read People's Journal issue today? Here, you have here a Filipino, a Pakistani, and an Indian arrested by Saudi Arabian authorities while they were gambling, which is prohibited in Saudi Arabia. So what was their penalty? 50 lashes. Do you know what is lashes? Yung ginagamit sa kabayo. 50 lashes. So, Filipino, Indian, Pakistani, they will be lashed at the town plaza. So, the Saudi general will implement 50 lashes against them. But before that implementation, the general said, since we are just through with the Ramadan, I am giving you one request before I will implement it. What is your request? Asked the Pakistani. What will be your request, Tam, if you will be the one to hit with 50 lashes? The Pakistani said, "Me, I request for a pillow, Your Honor, to be placed at my butt." So, ipilo. But after 20 lashes, wasak na yung pilo, hirap na hirap siya sa lashes. He could not walk. So the next, yung Indian. What is your request, Mr. Indian? Please give me 2 pillows. So 2 pillows. But since it was very strong yung pagkalas ng general, after 3 lashes, sirang-sira na yung 2 pillows, he has to endure the remaining 20. And then, the general asked the Filipino, Mr. Filipino, since Philippines is very close to Saudi Arabia, there are many Muslims in the Philippines. I am giving you 2 requests. I am giving you 2 requests. So, kung ikaw, Sam, anong request mo?
Attorney, painkillers po.
Painkiller, masama pa rin, nasakit eh. Katamaan kahit na hindi mo ma-feel yung pain, red na red yung buttocks mo. Pero yung Pilipino, ang galing. I am giving you 2 requests. And then the Filipino said, Mr. General, please hit me 200 times. You can just imagine, very brave. So the Saudi general said, really, Filipinos are very, very brave. Talagang you're very brave. I admire you. What is your second request, Mr. Filipino? So, kung ikaw, Joshua, anong second request mo?
Hit me with the pillow na lang po, attorney.
Hindi. He's very good eh. Please put the Pakistani at my back. So, it was the Pakistani who was hit 200 times. Correct? Ganun sana kayo kagaling na mag-isip. Tingnan mo, construction worker, pero naisip niya yan. So, it was the Pakistani who suffered 250 lashes. Okay? Now, let's proceed now to the most interesting part of your constitutional law. Now, these are now the last 3 questions in your finals. Right against double jeopardy. Now, it says there that no person can be twice put in jeopardy for the same offense. Take note, you cannot be twice put in jeopardy. You were tried, you were acquitted, and then the fiscal said, we found new evidence, can we try you again? That cannot be. Now, take note of the second part, however. That was not present in our previous constitution. That is not present in the U.S. Constitution. That is a new provision. If an act is punished by law or an ordinance, acquittal or conviction either shall bar prosecution in the other. So take note, the act is punished by law in an ordinance. If you are acquitted or convicted in one, you can no longer be charged or tried in the other. Take note of the case of People versus Judge Rilova. This was asked 5 times already in the bar exam. So here, in Batangas City, the members of the Batangas Electric Cooperative, while going over to the different establishment in the city, they found out that Batangas Ice Plant used jumper in order to cheat in their electric consumption. So, jumper, stealing of electricity. But there is an ordinance in Batangas City punishing theft of electricity. So, there is a ordinance of the city punishing theft of electricity. So, the officials of Batangas Ice Plant were charged of theft of electricity under the ordinance of Batangas City. After the accused were arraigned, the judge said, Fiscal, will you look at your timeline? It appears that you filed the case after 62 days. 62 days. What is the materiality of that, Ara? Criminal cases punished by ordinances, city, municipal, province, prescribes in 60 days. That is what you studied in your criminal law 1. 60 days. So you have to file within 60 days. So here, it was filed on the 62nd day. The judge said that case prescribed. So the judge dismissed the case. What did Fiscal Joshua did? He said, no, I will file another theft case, theft of electricity under Article 309 of the Revised Penal Code because the prescriptive period of 309 is 4 years. Therefore, I will file again. So there is another case, theft of electricity under the Revised Penal Code. Question, can the new case prosper? Very easy. Just read your second sentence. Why? Because they were already acquitted or the case dismissed insofar as the ordinance of the city of Batangas, and therefore they could not be charged again using the revised penal code. Very, very clear. Now, let's go to the requisites of double jeopardy. Take note of this one. Almost every bar exams, we have this. There are 4 requisites of double jeopardy. 1, there must be a valid complaint or information. What do you mean by valid complaint or information? There must be an information filed and signed by the city prosecutor or provincial prosecutor of the place where the crime was committed. So, if the crime was committed in Baguio City, the information must be signed by the city prosecutor of Baguio, or if not the city prosecutor of Baguio, by the Secretary of Justice. So, valid complaint or information. Second, it must be filed in a court of competent jurisdiction. No. So, what do you know about the court of competent jurisdiction? You know jurisdiction. For example, murder, RTC. RTC. Slight physical injuries, MTC. But what we are talking about here is a different jurisdiction. What kind of jurisdiction? If the rape was committed in Baguio City, it must be filed in the RTC of Baguio. That is what we mean by court of competent jurisdiction. So, RTCs have jurisdiction over rape cases, but not all RTC can try a rape case happened in Baguio City. Only the RTC of Baguio, no other RTC, except if there is a transfer of venue authorized by the Supreme Court. Third requisite, the accused was validly arraigned. Take note of the word, validly arraigned. And the fourth one, of course, this one is your question number 21 because we have 25 questions. Each question is 4 points each. So, the fourth requisite, the accused was convicted, acquitted, or the case dismissed without his express consent. So very clear. The requisites so that you could invoke double jeopardy are: 1, there is a valid complaint or information. Second, it must be filed in a court of competent jurisdiction. Third, the accused was validly arraigned. And third, the accused was acquitted, convicted, or the case dismissed without his express consent. So, let us now go to the cases that will illustrate this requisite. Let's go to the case of Kuja versus Court of Appeals. So, Kuja was arrested in what is that northernmost town of Pampanga? I forgot what's that. It starts with M.
Mabalakat, sir.
Yes, Mabalacat. He was arrested in Mabalacat with unlicensed firearm. Now, here, he was charged and he was tried at the RTC of Pampanga, but take note, the RTC of the province of Pampanga are all found in Angeles City. So, there are two kinds of RTC in Angeles City. RTCs for the city of Angeles and RTC for the province of Pampanga. Why? Do you want to have it there? Why? Yan ang maraming nightclubs maybe. Why? Because that is near your Clark Air Force Base and they have plenty of GROs there. Now, trial was already halfway before the RTC of Pampanga. So, correct court was it a correct court? It happened in Mabalacat. So, the correct court, RTC of Pampanga. So, the RTC of Pampanga, even though located in Angeles City, was the court of competent jurisdiction. Now, was he validly arraigned? Yes, he was represented by a very good lawyer. But at the middle of the trial, the judge discovered that the person, the prosecutor who signed the information was not the prosecutor of Pampanga, but the city prosecutor of Angeles City. Question: does the city prosecutor of Angeles City has any business signing the information for a crime committed in Mabalacat, Pampanga? The answer is no. So, the judge said, there is no valid complaint or information. I have to dismiss the case. Of course, the accused objected. Tuloy na lang natin, judge. Halfway na tayo eh. If we'll start again, that means I will have to pay my lawyer all over again another attorney's fees. But there is another case filed. This time, it is now a complaint or information signed by the provincial prosecutor of Pampanga filed before the RTC of Pampanga. So, Koja went to the Supreme Court and he said, there is already double jeopardy. Now, let's look. Now, what's the fourth requisite? The case was dismissed without his consent. That is present, correct? He objected to the dismissal. Third, was there a valid arraignment? Yes, that is present. How about the second? It was filed in a court of competent jurisdiction. Was it filed the first case in the RTC of Pampanga? Yes. So, requisite second, third, and fourth are present. Unfortunately, how about the first one? Was the first case a valid complaint or information? The answer is no, because the act happened in Mabalacat, but the fiscal who signed the information is the city prosecutor of Angeles City, who has no jurisdiction over Mabalacat, Pampanga. So there is no double jeopardy. One requisite was missing. Now, let's go to the case of People versus Galano. Galano was from Batangas. The complainant against him for staffa from Batangas. So you have now here your fiscal in Batangas filing a complaint on formation for staffa against Galano in the CFI of Batangas. And then it was tried in the CFI of Batangas. So, if you look at that as if it was perfect, there was valid arraignment. But at the middle of the trial, when the complainant was being cross-examined, it turned out that the money involved was handed by him to the accused not in Batangas, but while they were in Manila. So, was there a court of competent jurisdiction insofar as the CFI or RTC of Batangas? The answer is no. Why? The staffa took place in Manila and therefore trial shall be held in the city of Manila. So the first requisite, third requisite, fourth requisite are all present, but the second requisite was not present. Now, let's go to the case of People versus Balisacan. Do not forget the citation, 17 scrap, page 1119. It might be asked during your time. I have the list of bar examination question since 1960. This was asked 14 times already. 14 times already. So, very, very interesting case. So, we have here, Vance was charged of homicide before the sala of Judge Balisacan. Arraignment. What is your plea, Mr. Vance? Asked the judge. What was the answer of Vance? Guilty, Your Honor, but please allow me to present evidence of incomplete self-defense. So what is the plea? Guilty, but he is asking the court that he be allowed to present evidence of self-defense. The judge said, okay, we'll reverse the order of trial. You present your evidence of incomplete, not complete self-defense, incomplete self-defense. So, guilty, but he said, please allow me to present evidence of incomplete self-defense. So, he was allowed. What happened after Vance completed the presentation of his evidence to prove incomplete self-defense? What did the judge say? The judge said, gago, tanga. That is not incomplete self-defense. That is complete self-defense. I am now acquitting you. You go home now. So, he was acquitted. Correct? Because the judge said the evidence is complete self-defense. But the fiscal objected. Your Honor, may I be allowed to present by evidence to prove that there was no incomplete evidence or incomplete self-defense. What did Vance said? No, Your Honor, that cannot be done. Double jeopardy has set in. I was already acquitted. Therefore, you cannot retry my case again. So let's start. What is the first requisite of double jeopardy? Valid complaint or information signed by the fiscal. Is that present here? Yes. Second, Was it tried in a court of competent jurisdiction? Yes, he was tried in the CFI, which has jurisdiction of the homicide case. Let's go to number 4. Was Vance acquitted? The answer is yes. Now, what is left now is the third. If the third element is present, double jeopardy has set in. What is the third? That the accused was validly arraigned. Question. Was Vance validly arraigned, Mir?
No, sir.
No. If you are the judge, can you acquit an accused who said, I am guilty? No. Correct? That's why only an accused who entered a plea of not guilty could be acquitted or convicted. But if he entered a plea of guilty, you cannot acquit him. So, the judge should have, according to the Supreme Court, rearraign Vance. No longer guilty, but not guilty. So, in this case, there was no double jeopardy, correct? There was no double jeopardy. You can just imagine, he was only asking for incomplete self-defense, and the judge said, the evidence is complete self-defense. Ang swerte mo naman. That's why this was asked many times in the bar exam. So try to look for this question. The third requisite is not present. Why? There was no valid arraignment. The arraignment, the plea was conditional. He said guilty, but I must present evidence of incomplete self-defense. That cannot be done. Either guilty or not guilty should be the plea to be entered during arraignment. Now, let's go to your case of Dicini versus Secretary of Justice. I think I discussed this before. Cyber libel. You posted a malicious, libelous article in your Facebook account. And then, you also publish it at the Baguio Midland Courier. Question. Can you be charged of libel under Article 355 of the Revised Penal Code and libel under Republic Act 10791? Can you? No. That will be double jeopardy. You can choose whether it will be Article 355 the Revised Penal Code or 10791 Republic Act 10791, but not both. Why? It was the same act. There could have been two penalties. That is a clear case of double jeopardy. Now, let's go to the case of Bautista versus Court of Appeals and Sharon Cuneta Pangilinan. I hope you will read this one. Here, you have Bautista, my favorite entertainment editor of Bandera. Are you reading Bandera, April? So, here, Bautista in his column said, Sharon Cuneta is what? How will you describe yung masyadong mataba? And then he wrote so many bad things against Sharon. Aside from being sobrang taba, there are many other things. She said, pinapahirapan niya si Kiko Pangilinan, walang hiya ka, do you not know that your husband is a Harvard Law graduate for his MA and so on. So many libelous things written. So, a case was filed against Bautista, the entertainment editor Bandera in Pasig City. after Sharon testified. What will you do if you believe that there was no proof beyond reasonable doubt, Kathleen? Like what I did with Judge Pamintuan? You file a demurrer to evidence. So, Bautista filed a demurrer to evidence saying the evidence of Sharon was not sufficient to convict him. And the RTC of Pasig said, you are correct. We are now dismissing the libel case filed by Sharon Cuneta. Sharon Cuneta appealed to the Court of Appeals. She wants the case to continue. Unfortunately, the three justices in the Court of Appeals appear to be fans of Sharon Cuneta, and they said, yes, we continue. You, Bautista, you present your evidence. Can that be done? The Supreme Court said, no, there is already double jeopardy. If the case is dismissed based on demurrer to evidence or speedy trial, then double jeopardy sets in. Now, before we'll proceed further, look again at the fourth requisite. Acquittal, the accused acquitted, second, convicted, or the case dismissed without his express consent. Meaning, if he consented to the dismissal, he cannot invoke double jeopardy, correct? Yes, but there are two instances when you, even though the dismissal was with your consent, double jeopardy still applies. Now, take note of the two exceptions. One, when you file a demurrer to evidence. So, you are the one asking for dismissal. Was there consent on your part? Yes. Yes. But even if there is consent on your part, the dismissal bars further prosecution, there will be double jeopardy. Now, what is the other dismissal with the consent of the accused but will result to double jeopardy? What is that? The one I mentioned to you before. If the basis of the dismissal is speedy trial. Again, you have this one part of your final exam under the sub-questions on double jeopardy. So, even though the accused gave his consent to dismissal, if it is based on speedy trial and based on insufficiency of evidence or demurrer to evidence, still double jeopardy will apply. Now, take note, if you are acquitted, can the government file a motion for reconsideration because of your acquittal? The answer is no. Can the government file an appeal if you are acquitted? The answer is no. That's why if you are acquitted of murder today, listen, even though just coming out of the courtroom, and then you will shout in front of an ABS-CBN TV reporter, yes, ako ang pumatay, can they imprison you? No more. Why? Double jeopardy has set in. So very clear. Here, no appeal by the government, no motion for reconsideration, but there is that exceptional instance. The government can file a petition for certiorari under Rule 65 questioning the decision if the judge committed grave abuse of discretion. Grave abuse of discretion. And second, if the right of the people to due process was violated. Those are the only two grounds but not appeal. It should be certiorari under Rule 65. That is the case of People versus Sandigan Bayan and Imelda Romualdez Marcos. Now, let's go now to the very controversial case of Jason Eibler versus Judge Pedro of Pasig. Have you heard of Jason Eibler? This is the man who committed several crimes. He is the son of the sister of Freddy Aguilar. His father-in-law is the UK ambassador to the Philippines. So, father, stepfather. His mother married the ambassador of United Kingdom. Now, what is the case here of Jason Eibler? He was using the big car of his stepfather. He was driving negligently while he was at that flyover in Pasig. What happened? He bumped the Pajero of the Assistant Executive Secretary of GMA. So, Assistant Executive Secretary. He bumped the Pajero and the Pajero fell from the flyover to EDSA. And who are the occupants of the Pajero? The Assistant Executive Secretary and his wife. Who died? Who died? Very easy, correct? It is the wife. Mahirap mamatay yung asawa kasi masamang damo, correct? So, here, the Pajero was damaged. The wife died. The Assistant Executive Secretary suffered physical injuries. What did the Pasig prosecutor do? He filed 2 criminal cases. 1, reckless imprudence resulting to damage to property. Case number 1. Why? Because the Pajero was damaged. And criminal case number 2 against Eibler, reckless imprudence resulting to homicide and physical injuries. So there are 2. Today, Eibler was arraigned. So, they read the first one. What is the first case? Reckless imprudence resulting to damage to property. And then Eibler was asked, what is your plea, Mr. Eibler? Your Honor, guilty. Guilty talaga. Guilty. Very guilty. So, what is the penalty for reckless imprudence? Here, ano yung correct term na pagalitan ka, sabihin nila, Katrina, next time you have to drive properly, you have to observe the circumstances. What's that? A penalty? Yung may sasabihin lang sa'yo yung korte, advising you, what's that? I forgot the exact. But that is a penalty, ah. Do you remember what is that penalty in your first semester, Rex? Yung sasabihin sa'yo, Rex, next time you observe, you be very careful while driving your vehicle so that others will not be hurt and so on. That is the penalty. Walang fine, walang imprisonment. And then the Judge Pedro said, oh, arraign him in the second case. And what is the answer of Eibler? Your Honor, you cannot do that. You will arraign me in the second case. You will violate my right against double jeopardy. Can that be done? Really? Is there double jeopardy? The answer is yes. Why? There is a single act. You cannot divide that into 2 different criminal cases. That's why if during the accident 10 died, 10 seriously injured, 10 slight physical injuries, There is only one case. Why? Because there is only one act of negligence. So take note of that. Now, but of course, the fiscal and the judge are also graduates of Lausium University. It appears that correct naman sila. Will you please read your Article 48 of your revised penal code? Miel, do you have a copy or anyone among you here? Article 48 of your revised penal code. What does it provide?
When a single act constitutes two or more grave or less grave felonies, or when an offense is a necessary means for committing the other, the penalty for the most serious crime shall be imposed, the same to be applied in its maximum period.
But what crime is involved that? In order that you can complex it, what crime? Grave or
Grave or less grave felonies.
Okay, so the fiscal and the judge said somebody died here. So grave or less grave. That's why we cannot complex it with reckless imprudence. It appears na parang correct sila, correct? But take note, take note. The Supreme Court said Article 48 does not apply to negligence cases. That applies only in cases of crimes committed with dolo. Dolo, not culpa. So here, negligence, you have to combine in only one case. But if it is intentional, like murder, homicide, and so on, you can only complex grave in less grave. For example, serious physical injuries, slight physical injuries, that can be the subject of a separate case, correct? But that one applies to dolo, cases with intent, not negligence. So here, the case of Ebler, you can just imagine, he was not made to answer for the death of the wife of the assistant executive secretary. Take note of that. Now, the case of Lihano versus People. We said while before, in your presumption of innocence, they were acquitted by the Supreme Court, correct? Acquitted by the Supreme Court. Now, can the husband, Lauro Visconde, file a motion for reconsideration? As we said, if the case is already dismissed or the accused are acquitted, you cannot file a motion for reconsideration because double jeopardy has set in. So that cannot be done. Now, Dayak versus Senjong. If you are acquitted of a crime, can the complainant file a separate civil case to collect damages? You are acquitted in a criminal case. Now, can the complainant against you file a civil case to collect damages? The answer is it depends. If you are only acquitted because of reasonable doubt, the answer is they can still file a civil case against you. But if the decision says Rex did not commit the crime imputed to him, you can no longer file a civil case. So, it depends on the dispositive portion of the criminal case acquitting you. If it is only reasonable doubt, you might be charged again civilly. But if the decision says he did not commit staffa, he did not commit murder, then you cannot sue him for damages. Now, we said a while ago, can the state appeal an acquittal? No. Can the state appeal a conviction? No. No. Except if there is a grave abuse of discretion. Not appeal, certiorari. So you now have here the case of People versus Domingo. So Rex was charged of murder. After trial, he was convicted of homicide. Can the government appeal that so that it will be increased to murder? The answer is no. Can Rex appeal because he believes that he is innocent? Yes, he appealed the conviction for homicide. Now, can the appellate court sentence him for murder? He was charged in the RTC murder, but he was only convicted of homicide. He appealed in the Court of Appeals. The Court of Appeals said he is not guilty of homicide. He is guilty of murder. Now, can you complain of double jeopardy? The answer is no. Why? Because if the accused appeals a case, he is asking the appellate court to review the case all over again. And if the review shows that he is guilty of murder, he can be penalized with murder. So, he was trying to extend his luck. Kinundik na nga ng homicide, hindi pa kontento. Nag-appeal, now he is convicted of murder. So, very, very clear. Now, I told you a while ago about the certiorari. Can the government appeal a conviction? No. Can they file a petition for certiorari? Yes. So, you have the case of Villarreal versus People. This is the one I told you before, involving the killing of that first-year law student through hazing. You remember that? So, you have here the son of the BIR commissioner, Lenny Villa. After trial, the 35 accused here, they were all convicted of homicide. Homicide. Correct? Homicide. Can that be questioned by the prosecution? Kasi homicide yung dalawa. The rest are physical injuries. Why? Because the 33 accused were the ones who conducted the hazing. But after the 33 conducted the hazing, yung dalawa, buhay na buhay pa. Buhay na buhay pa si Lenny Villa. But the president and vice president of Aquila Lihes arrived and said, reopen, we will participate also. So, they now committed other acts against Lenny Villa. But after the two initiated Lenny Villa, he suddenly was having difficulty breathing. They brought him to the hospital. He died. Now, is it only the last two who shall be liable for homicide, but the first 33 who also inflicted injuries to Lenny Villa, only physical injuries? Because at that time when the two arrived, the last two officials, Lenny Villa was still breathing normally. The Supreme Court said the penalty should be, take note, the penalty should be reckless imprudence resulting to homicide. Wala pa noon yung anti-hazing law. Now, there is an anti-hazing law passed in 1995 that is already equivalent to murder. Now, was the penalty homicide correct? The answer is wrong. It should be reckless imprudence resulting to homicide, not only for the 2, but also for the 33. Why? The death of Lenny Villa was not caused by the last 2 officials only. Nahirapan na siya sa 33. It was only made more serious by the inflicted injuries by the last 2. Understood? Example, Rex borrowed the car of Vance. That car was used already by Vance for the last 2 years. Hiniram ni Rex ngayon. Nasira yung gulong. Kasalanan lang ba ni Rex yung paggamit niya today? Why the tires were destroyed? No. The fact that it was destroyed today, that is the totality of the fact that the tire had been used since 2 years ago. So all of them are liable. Pero only reckless imprudence resulting to homicide. Now, take note of the case of People versus Judge Hernando. The judge made a mistake in his judgment. He acquitted the accused. So, wrong in the appreciation of evidence. The government appealed it in the Supreme Court. And the Supreme Court said, it appears that Judge Hernando made a mistake in the appreciation of evidence. Can we reopen the case? The answer of the Supreme Court is no. If the judge only made a mistake in the appreciation of evidence, double jeopardy has set in. But if he committed grave abuse of discretion, it can be reopened. So take note of the difference. Now, we mentioned to you a while ago, when we discussed speedy trial, 3 consecutive failure of the prosecution to present evidence, and Attorney April moved for the dismissal, invoking speedy trial, and the case will be dismissed. Will there be double jeopardy? The answer is yes. But take note, the invocation of speedy trial must be in good faith. Now, you look at your case of People versus Puente Villa, 100 scrap. So you have here, it is a case for homicide. Case for homicide. So, first hearing, Fiscal Rex moved for resetting because he was not ready. First hearing. Second hearing, Fiscal Rex again moved for resetting. Why? Because his witness was allegedly sick. But the judge said, you present your evidence on May 22. Otherwise, if you cannot present your witness, I will dismiss the case. Very clear. Kasi pang tatlo na. What happened here? Tomorrow, nagkita si Attorney Kathleen at saka si Fiscal Rex sa SM. And Fiscal Rex told Kathleen, Panyera, pariset ko yung hearing natin sa Lunes kasi I have to go to Manila. Why? At last, my mother-in-law died already. So, can you just imagine? At last, my mother-in-law died already. So, he wants to see that indeed her mother-in-law is dead so that his wife will inherit the properties of the mother-in-law. So, what was the answer of Attorney Kathleen? Oh, okay, Panyero. Okay, Fiscal, I understand. You do not need to file a motion to reset. I will not go to court on Monday. naintindihan naman kita eh. Happy ka namatay yung mother-in-law mo. So I will not go to court on Monday. So what happened on Monday? Last day for the fiscal to present evidence. But Monday, the fiscal was not there. There was no motion for postponement. In fairness to Attorney Kathleen, she did not appear also. The problem is her associate, Attorney Wilfreda, was in court and she was already saying, Your Honor, dismiss the case. That is a violation of my client's right to speedy trial. Imagine yung fiscal hindi pa nag-file ng motion for postponement. So, the judge dismissed the case. Judge dismissed the case. Sinong nag-appear? Yung associate ni Attorney Kathleen, invoking the right to speedy trial. Now, after 1 week, dumating si Fiscal Rex. Talagang namatay yung mother-in-law niya. He was very happy. But when he went to his table, he saw the order dismissing the case. He filed a motion for reconsideration. He wants to reopen the case. Question. Attorney Kathleen is now saying, there is already double jeopardy. The case was dismissed based on speedy trial and therefore double jeopardy has set in. Is she correct? The Supreme Court said no. Why? Because Attorney Kathleen did not invoke speedy trial in good faith. She knows that Attorney Rex will be absent on Monday. Kung hindi sana yung assurance niya, huwag ka nang mag-file ng motion for postponement fiscal. If you filed a motion for postponement citing the death of your mother-in-law, the judge would have granted it. He would not have dismissed the case. So, this one, if you will see Fuente Villa, it was even Attorney Kathleen who was cited for contempt. Why? Because she was making a mockery of the processes of the court. So take note of that. Now, before we will end your double jeopardy, take note of the case of People versus City Court of Silay. This one is a comedy of error, plus the judge, the fiscal are both graduates of Lauseum. So here, Arvin was charged of grave coercion. Grave coercion. It was filed in the MTC of Silay City. He was arraigned. He was arraigned. What was the plea of Arvin? Not guilty. Grave coercion, MTC. After his arraignment, the judge said to the fiscal, Fiscal Rex, parang wrong yung pinag-filean mo eh. Dapat grave coercion, it should be filed in the RTC. And then, fiscal and the judge discussed while the lawyer of Arvin did not participate. But tapos na yung arraignment niya. Anong sinasabi ng judge? Dapat sa RTC to Yan, correct ka ata judge. And then the judge dismissed the case. So, tapos ng arraignment dinismiss yung case ng MTC judge. So, the fiscal Rex filed a grave coercion case in the RTC. Take note nung bago pa yung BP 129. So, there is a case filed in the RTC. Grave coercion against Arvin. That is the second case against him. Now, when Arvin was called for arraignment in the RTC lectured Fiscal Rex. Fiscal Rex, Hindi mo ata nabasa tong bagong decision ng Supreme Court. Grave coercion should be filed in the MTC. So, what did your RTC judge do? The RTC judge dismissed the second grave coercion case against Ervin. So, anong ginawa ni Rex? Nag-file ng third information for grave coercion balik sa MTC. Now, today, does the MTC judge agreeable that grave coercion should be filed with the MTC? Yes, he is now convinced. The fiscal, yes, convinced that dapat MTC. Now, the MTC judge said, Arvin, stand up for arraignment. And what was the answer of Arvin? No, Your Honor, you cannot arraign me again for the third time. Double jeopardy has set in. Was there double jeopardy? First, was there a valid complaint or information sa first grave coercion? The answer is yes, filed by Fiscal Rex. Second, was the first grave coercion filed in a court of competent jurisdiction? Yes, MTC, correct. Third, was Ervin validly arraigned in that first grave coercion case in the MTC? Yes. Fourth, the case was dismissed without his consent. Sino lang yung nag-usap na walang jurisdiction ng MTC? Yung fiscal at saka yung judge. Walang consent si Ervin. So, all the four requisites are present. So, double jeopardy because tanga yung judge at yung fiscal. Now, before we leave this is the last question on double jeopardy so that I will not be wasting your time. This is really part of your exam. What is the supervening fact doctrine? Supervening fact doctrine. You read section 7, rule 117 of your rules on criminal procedure. Supervening fact doctrine. What's that? Or let's say, one day, Vance boxed Arlene several times. She fell to the ground. She suffered black eye and so on. She was hospitalized. While in the hospital, Vance was now charged of serious physical injuries. He entered a plea of guilty. He was sentenced to 5 months in prison. So, nag-plead guilty, correct? 5 months in prison. After that, 3 days later, the victim died. Can you charge Vance of homicide? Can you charge him of homicide? The Supreme Court in the case of Tarok said no more. Double jeopardy has set in. Take note that these cases here, the Supreme Court reversed themselves 6 times. 6 times. So, what happened in Villasis? Ganun ulit. Binugbog mo si Josephine. Na hospital. You were charged of serious physical injuries. After 1 week, she died. Can you be charged of homicide? The Supreme Court said yes, based on the supervening fact doctrine. Meaning, pagkatapos kang na-filean, there is a supervening fact. Ano yung supervening fact? Namatay yung victim. Hindi lang physical injuries. So can he be charged of homicide again? Yes. But the condition is, if he will be convicted of homicide, dapat ibawas mo yung penalty that he served for physical injuries. Do you understand? Kung ang penalty ng homicide is 10 years, he was penalized for 1 year sa serious physical injuries, and he was able to serve 1 year already, you cannot imprison him for 10 more years for homicide. Dapat ibawas mo yung 1 year. Otherwise, unfair kay Vance. Dapat namatay na lang na diretsyo upang 10 years lang. Correct? But if you add 10 years and 1 year, di naging 11. Mas maganda na lang sanang namatay na diretsyo. So, that is what is the supervening fact doctrine. That is one of the sub-questions on double jeopardy. I hope you will not forget that for your finals. Last, we will go to the ex post facto law. What is ex post facto law? There is a law that punishes an act which was innocent when the act was committed. Ex post facto law. What are the requisites? 1, it is a penal law. Penal law. Second, it is given retroactive effect. And third, it is prejudicial to the accused. Prejudicial to the accused. Now, we discussed before Lacson versus Sandigan Bayan. Before, ang jurisdiction ng case ng police officers who are involved in killing a person is Sandigan Bayan. After that, while the case was pending, there is a new law that states jurisdiction shall be with the RTC where the crime was committed. Crime was committed. Lacson went to the Supreme Court. Oy, ex post facto na yan ah. Bakit nyo ina-apply sa akin? Why are you applying it to me retroactively? Was there ex post facto law? When he committed the crime, wala pa yung law na yan saying RTC. Ang law noon, Sandigan Bayan. Now, the new law is being given retroactive effect. Is that ex post facto law according to Lacson? The answer is no. Why? Because what is the first requisite again? It must be a penal law. Eh ano yung law? Law only to change which court has jurisdiction. So hindi penal law. So if it is not a penal law, even though you give retroactive effect, there is no ex post facto law. Very clear. Take note again that even if a criminal law will be given retroactive effect, if it is favorable to the accused, it is not ex post facto law. Now, what are the different features of ex post facto law? 7. That is question number 25 in your finals. I think I gave you my reviewer. That is the last part of the reviewer in Bill of Rights. There are 7. What are the 7 features of ex post facto law? I'll give you example of the first one. What is that? It was innocent at the time it was created. Example, Rex, today, you were having face-to-face classes at UC. Umuwi kayo ngayon, naiihi siya. So he urinated between 2 vehicles along Session Road. Nakuha yung CCTV. Kitang-kita talaga. It was Rex urinating. Today, May 19. The evidence is very strong. Tomorrow, May 20, they will enact an ordinance in the city of Baguio criminalizing urinating along Session Road with imprisonment of 2 months. So, next Monday, they will file a case against him for violating the ordinance passed yesterday. The evidence is there. Si Rex umiihi, hinahawakan niya, kitang-kita. Now, can you apply the law to him? The answer is no. Why? Today, wala pang ordinance na ganon. It was still innocent. It became a crime only tomorrow. That is the classic example of the first one. But take note, those 7 are very, very short. That is question number 25. You can write it, okay? Now, I hope you were able to learn something from me. I'm very happy to be with you for this semester. I'm very, very sorry that I was not like before when I lecture 20 hours on weekends, 16 weekends continuously in Visayas in Mindanao. But as you know, I suffered stroke. That's why I do not even want to accept your class before, but the dean twisted my hands. I hope that you are able to learn something. I'm very, very sorry if I have shortcomings. As you can, as you might have observed, at the end of our class, there is a change in my voice. Sorry, I'm still recovering. But to tell you the truth, I gave my best. I want you to pass the bar exams. I want you to know constitutional law. That's why I'm very happy because the 259 who passed the bar exam, more than one half of them texted me, messaged me, and said their highest grade is political law. That's why that inspired me to teach even though I am hard up, as you can see here, 3 hours instead of resting. I think mayroon naman akong kita except my salary at UC. But I just want to pagbigyan si Dean because he said, no, we want you at UC Law. The Salbosas want you to return, and President Salbosa, Chairman Ben, the one who died, they were the first together with the dean who visited me at Notre Dame when I was already there, when I was brought from St. Luke's on May 24, 2018. That's why here, I want all of you, if you have questions, I said, I gave you my telephone number. You can just text me. I'll be the one to call you. If your number is smart, text my smart number, only call naman yan, I will be the one to explain to you. Basta not past 1 o'clock in the morning. Kasi by that time, natutulog na ako. So, I hope that you learn something here. I gave everything that I know. I did that. I want, because it's useless if I will teach you and then I will not give all what I know, you will not pass the bar. That's very bad for me. That it will not reflect on my ability. Aside from that, gusto ko na papasa kayo lahat. Why? Upang magkalaban tayo sa korte. And medyo dibaldi yung kliyente ko. Sabi ko, Kathleen, convincein mo na yung client mo na arigluhin natin. And then, maybe, she will talk to her client and then maariglo yung kaso. Correct? Unlike other lawyers. That's why I want all of you to become lawyers, and even if you are already lawyers, you want to consult me on anything like constitutional law, you are free to collect the other lawyers, even lawyers who are already 10 years in the practice of law, judges, when we deal with constitutional law, they even call me, like Judge Israel, my student, RTC of Dagupan. He talked to me for 2 hours last night That's why I said we stopped at 8:30 last night. Dapat sana'y tinuloy. He called and I have to entertain him. So, when will be your final exam? When? What date next week? Do you
Wednesday
have
po.
what?
25.
May 25 po.
What day is 25?
Wednesday po.
Okay, Wednesday. The schedule is from 5:30 to 7:30. But me, I will give you up to 9:30 because my exam is long and hard. I will be patiently waiting for you up to 9:30 if you will not be able to finish it at 7:30 or 8:30. And aside from that, I am not fond of checking your permit. No, there's no need to show me your permit. Okay? We'll be using the same link for Wednesday. Good luck. If you have questions, you just call me and then I'll explain further. Okay? Good night and good luck.
Attorney,
Okay?
sorry po.
Yes?
Attorney, sorry po. Can we take a picture po with everyone? So we'll have remembrance po with all the sections.
Okay. Okay.
Thank you, Attorney. Can I ask Joshua to take a picture, please?
Many are with their cameras off ata based from my monitor. Okay? At least I see you smiling. Noreen, Casey, Michelle, Lorraine. So, it seems that you were able to learn something from me. Kahit na maliit lang. Kahit maliit lang. Okay? Sige. Are you through taking the
Ay,
picture? Okay.
so 2 pages. So ngiti lang kayo. 1, 2, 3.
You tag me in my account. Okay?
Wait lang po. Yung second page.
Okay? Tingnan mo yung smile ni Sunny talaga from ear to ear Okay?
Ay, wait lang po. Technical difficulties.
Okay? Sige. Dian is wearing a mask. Why? Do you have companion there?
Attorney, I'm on my way to Baguio.
Okay. You're inside the car?
Bus attorney.
Okay, okay, okay.
Okay, second page ready po. So, 1, 2, 3. Okay na po.
Okay. Enjoy your dinner. Sorry, late kayo ng 10:25 na, correct? Okay? Okay?
Sir,
Yes?
baka may palas recitation score daw sa mga present tonight, sir.
Yes. Today, all of you are,
Mauna na po si Jake.
nakita ko pa si Pen ngayon, wala siya kahapon. So, she will have a recitation grade today. Pen, you were not here yesterday, but I saw you a while ago. May I hear your voice? Pen? Yes, correct? I cannot hear you, Pen.
Yes, sir, I'm here.
Okay, sige, very good. You will have 2 recitation grade today, okay? Okay, please review properly and then I might post on Monday the questions. For example, 3 questions on right during custodial investigation, 2 questions on imminent domain like that. Rights during criminal trial, nandyan. Right against self-incrimination, nandyan. Cruel and unusual punishment, you have double jeopardy, you have ex post facto law. So that you will all get perfect score. I just want to see how you will answer it. Okay? Because here I'm already very contented of your performance. That's why tomorrow again I will be very sad because I am having my class with the other school and then comparing your performance with them. Parang ang tanga akong magturo. Unlike you, I'm not trying to inuuto kayo, but really, I'm very contented. You are even better than the last that I handled. Yung mga pumasa na yan, mas magaling kayo sa kanila. Oo, totoo. So, continue your habit in studying. With that, you read. Political law is very easy. No question about it. Even during your second year or third year, if you have questions involving political law, constitutional law, feel free to call me. If you think that I know the answer to your question, you can call me. Okay? Criminal procedure, evidence, these are already covered by constitutional law. Okay? I will not delay your supper anymore. Let's adjourn. Thank you.
Thank you po.
Thank you, sir.
Okay.
Thank you, sir.
Thank you so much, attorney.
See you during your fourth
Yes,
year
sir.
if I'm still
Thank you
alive.
po.
Okay?
Oo naman, attorney.
Thank you po, attorney.
Ayun po.
Parang ayaw po namin umalis.
Okay. See
Hindi, joke lang po. Thank you po, attorney. Bye po.
Good night po.
you. Good night.